Thank you, Steve, and I appreciate this opportunity to have a discussion with Ryan. I've discussed for many years with one of his co-authors, my colleague Robbie George, and also now a couple of times with Sharif, so I'm completing the triumvirate here, which is a pleasure. I respect their argument and have engaged it for quite a while. Robbie was on my dissertation examiners at Princeton, and put me onto the work of John Finnis and others, which I have interacted with now for over 25 years. All right, so I'm going to, the book I'm just going to say addresses three questions. I think in a way it's a defense of the emerging common sense of the American public. It defends same-sex marriage, but also marriage as an institution and monogamy, and argues that all three go quite well together. I'm going to draw a little bit from the book in some of my remarks because it's in a way responding to the slippery slope argument that's been expressed a number of times by people on the political right, Justice Scalia most notably, but many others as well. And yeah, I think what makes that interesting, not only that the argument is there coming from the political right, but the fact is that many on the left embrace various items on the slope, and not just sort of marriage privatization or other kinds of radical reforms, but also plural marriage, sometimes in the form of what's called polyamory, or egalitarian plural marriage, something that exists mainly in articles written by academics and blog posts and the media. I'm not going to talk that much about that in my remarks because we're going to focus on Obergefell and other things, but I'm happy to come back to that afterwards in questions. I'm going to address the three questions that Steve posed for us, starting with the question about the majority decision in Obergefell earlier this summer, establishing same-sex marriage rights under the Constitution for same-sex couples. Was the decision was it properly decided? And I think the answer to that is clearly yes. The principles of liberty and equality under our Constitution strongly argue for marriage equality. And I think in part because the arguments on the other side have proven to be so weak, which is what I'll mainly emphasize here, focusing in part on Ryan's argument. Now, one thing we confront here immediately is the astonishing shift in public opinion. Why has that happened? I think it's partly been people coming out of the closet, the more favorable media representations. But I think one of the things that people have come to realize, which is very important from a substantive angle, is that if you go back 20 years, the majority of American public opinion thought of people being gay or lesbian based on a kind of lifestyle choice. The idea of sexual orientation has slowly seeped into the consciousness of the majority of the American people. And that, I think, itself has made a huge difference. That it's not a lifestyle choice, it's something that people are born into. And then what? What exactly are people supposed to do? How are they supposed to lead their lives? What constitutes a reasonable way forward given that fact? So I think that has made a huge difference, and that has gone along with people, as I say, coming out of the closet and so on. Now, the other thing that's been, I think, very important here, and we were just actually talking about this a little bit at the table, there's this sort of academic idea that has in fact made a huge difference in practice. It's not really an academic idea. The academic idea has been drawn from American constitutional practice, which is that when we're shaping sort of fundamental rights and liberties, there's been a basic norm and commitment that religious convictions, sectarian religious convictions, are not an adequate basis for shaping especially our most fundamental rights and liberties. That what's required are public reasons, public evidence that appeal to common sense, that justify the way that we shape our most fundamental rights and liberties in particular. And that norm has been in the background of this debate about same-sex marriage from the beginning, from when I started talking about it with Robbie George and others. And I think to the credit of the scholars in the new natural law tradition, they have accepted it and have accepted the challenge to try to articulate, a publicly reasoned case for why, in the first instance, all same-sex sexual activity should be regarded as immoral, and then secondly, why marriage is necessarily heterosexual. And in fact, those two things go together. Those two parts of the argument, it seems to me, are essentially linked, though the novelty of the book, What is Marriage, that Ryan Anderson has co-authored with Robbie George and Sharif Georges, is that it largely leaves out the sexual morality and focuses on the question of marital norms and why those norms can only exist in a heterosexual marriage. So I'm going to focus on that part of the argument, leaving out the sexual morality. And I don't think that part of the argument works very well without the sexual morality. I'm going to have to probably refer to parts of it inevitably. But I'll focus on this argument because it is the one serious philosophical argument for defining marriage as essentially heterosexual. The other arguments are more practical, prudential. The channeling argument, I think, has been the principal one, and there are a variety of other arguments. Obviously, arguments concerning children's well-being, which has involved evidence and so on as well, is also important. But I'm going to focus on this philosophical argument. We could talk about the other things later. So, the view that's articulated in What is Marriage places sexual intercourse at the center of marriage. It's the coitus or intercourse that consummates a marriage, whether or not one of the parties to the marriage is sterile. So this argument, the claim is that marriage is essentially heterosexual because marriage is the type of relationship oriented towards the good of new life, towards permanence and exclusivity, because it's consummated in coitus or intercourse. It's a union, and I quote, whose norms and obligations are decisively shaped by its essential dynamism toward children, the argument is, and I quote, and that dynamism comes not from the actual or expected presence of children, which some same-sex couples and even cohabiting brothers could have, that is, have actual children, and some same-sex couples lack, some opposite-sex couples lack, that is children, but from the way that marriage is sealed or consummated in coitus, which is organic bodily union. And it's on this basis that Georges, Anderson, and George insist that same-sex couples are not, and I quote, denied the right to marry. They're rather ineligible for marriage by nature. Same-sex marriage is a moral impossibility because same-sex couples cannot mate. No coitus, no marriage. Georges and Anderson and George call this the luminous truth and a universal moral reality, that marriage is a two-in-one flesh communion, referring to the book of Genesis. In other words, according to these philosophers, and I'm gonna put this, but I mean, it's a bit of a translation that may be considered to be unfair, but I'm gonna put it this way, I think I say this in the book. It's the baby-making sex, not the babies, that makes sense of marital norms of two-ness, permanence, and exclusivity. That seems to me a kind of startling claim, stated in the way it's stated in the book. Marriage is possible, they say, and I'm quoting, between only two, because no act can organically unite three or more, and thus seal a comprehensive union of three or more lives. In the text of emphasis, I've added some emphasis, but not necessary here. In other words, marriage is possible between only two, they argue, because only two people can have intercourse at the same time. Now, no defender of polygamy would be moved by that observation, which seems to be more or less irrelevant to what goes wrong with polygamy as a social form. And it does go wrong as a social form, as we can observe in human history. But the reasons for favoring monogamy over polygamy, for example, have to do with the substantive evidence of what it amounts to in practice. Overwhelmingly polygynous. Polyandry, one sort of wife with multiple husbands, only exists under extremely unfavorable circumstances. And polygamy tends always to give rise to inequality and conflict within families and within society. The nature of the sexual act doesn't really have anything to do with it. Children, spouses, and society benefit, on the other hand, from stable, healthy, two-person marriages. And that's what same-sex couples are seeking. But it seems to be bizarre to say, as Georges, Anderson, and George argue, that intercourse itself, with no babies or possibility of babies, and I quote, requires permanent and exclusive commitment. Again, it's the tendency of baby-making sex to actually make babies that furnishes a reason, I think, for thinking that sex and marriage should go together. I accept that. This is the channeling argument, which has been prominent in public debates, and I'll say a couple of words about it in a minute. But the new natural law insists that marital norms come, and again I quote, not from the actual or expected presence of children, but rather from the kind of sex that consummates marriage. Now look, this has been subjected to a whole host of objections. I'm just going to mention one. You guys are probably familiar with this. The double standard for infertile heterosexual couples. Natural law proponents consistently hold that even when it's impossible for heterosexual spouses to conceive a child, marital union itself is a great good. I accept that. Joining mothers to fathers in friendship. But if there's no possibility of procreation, then what makes the sex acts of sterile heterosexual couples part of their marital good? Why do sterile heterosexual sex acts, unlike homosexuals, have procreative significance, as they argue? So this new natural law argument has not featured in prominent federal court decisions. It was tried in a way, it was gestured to by Charles Cooper in California and at the United States Supreme Court. He started to make the argument that marriage is about procreation, and the argument didn't go anywhere. It led to laughter. And if we shift our attention from focusing on the sex act that consummates a marriage to actual people's lives, the claims seem obviously wrong in terms of what people care about in marriage. I mean, there are many heterosexual couples who are childless by choice, and if we compare them and their eligibility to marry with the hundreds of thousands of same-sex parents actually raising children who seek to marry, how is it that we can say that heterosexual marriage is necessarily and by nature more oriented to children than these same-sex couples who are actually raising children? I don't understand this as a matter of public philosophy, and I don't think many Americans do. So the entire perspective, it seems to me, is distant from anything, I think this is an additional point, is quite distant from anything resembling sympathetic engagement with the lives of actual people. On this view, and again I'm going to quote, even if a gay couple loves and commits to caring for and supporting one another, and also to raising a child together, Georges Anderson and George insist that there's no resemblance between them and a married couple. They dismissively remark, and I quote, "Just deciding to rear children together is not enough to make you married. 3 monks who commit to caring for an orphan do not thereby marry." Now, why say such a thing? It's because, and again, quoting them, marriage is a special kind of friendship uniquely embodied in coitus. In any case, I could quote from the same-sex couples who have been actual litigants before the courts, and their lives are quite different, I think, from those depicted in the What is Marriage book. If the procreative argument that I've mentioned, admittedly not fleshed out sufficiently in the time available to me, I'm sure Ryan will do a much better job, but if this argument for excluding gays from marriage seems obscure, the fairness argument for including gays has been stated clearly by no less a philosopher than Alec Baldwin, and I quote, "Beyond any issues of infertility or illness, there are men and women who are married in the eyes of the state, enjoying all the legal benefits, who have no intention of having children. They seek only companionship and all of the entitlements that come with marriage: sex, joy, partnership, caring. All of this is theirs, even though they will never bear children, and willfully so. If the state says they're free to do that, why aren't gay couples as well?" And evidence suggests that Alec Baldwin is correct. The benefits that accrue to heterosexual couples are also available to homosexual couples. Numerous studies show that people in reasonably happy marriages have better physical and psychological health, lower mortality rates, increased longevity compared to single people. This is especially true for men. Marriage doesn't do much for women, but it does a lot of good for men in terms of these various indices. And the benefits flow not only to the couples, but to society in the form of better health and productivity, as Ryan and his co-authors mentioned, lower rates of violence, drug abuse, alcohol abuse, and so on. And all of these same benefits flow to same-sex couples. Justice Margaret Marshall of the Massachusetts court put it well. "The marriage is procreation argument singles out the one unbridgeable difference between same-sex and opposite-sex couples and transforms that difference into the essence of legal marriage. The marriage restriction impermissibly identifies persons by a single trait and then denies them protection across the board. In so doing, state action confers an official stamp of disapproval on a destructive stereotype that same-sex relationships are inherently unstable or inferior to opposite-sex relationships and not worthy of respect." All right, let me move on to the other, as I say, popular argument, and I'll be much briefer now, the channeling function. This was referred to very frequently in federal court opinions, including the ones that led up to the Supreme Court decision in June. The channeling function was referred to by the legal group associated with the House of Representatives that filed a brief, and the way they put it was this: the link between procreation and marriage, this is a different way of thinking about the link between procreation and marriage, reflects the unique social difficulty with opposite-sex couples that is not present in same-sex relationships, namely the undeniable and distinct tendency of opposite-sex relationships to produce unplanned and unintended pregnancies. The legal arm of the House of Representatives, especially the Republicans in the House of Representatives, put it this way: it's no exaggeration to say that the institution of marriage was a direct response to the unique tendency of opposite-sex relationships to produce unplanned and unintended offspring. In other words, writes Judge Richard Posner, and I quote, "Heterosexuals get drunk and pregnant, producing unwanted children. Their reward is to be allowed to marry. Homosexual couples do not produce unwanted children. Their reward is to be denied the right to marry." Go figure. Posner pointed to another anomaly. The states of Wisconsin and Indiana were among the states that he was, whose decisions concerning same-sex marriage he was overseeing. Those states generally prohibited marriage among close relatives, including first cousins. But they made in their law an exception for heterosexual first cousins who are 65 or older, because those cousins cannot procreate. So the state carved out a special permission for some heterosexual couples to marry because they cannot procreate, while excluding same-sex couples in general from marriage because they cannot procreate. The inconsistency is glaring. As Posner puts it, and I quote, "Elderly first cousins are permitted to marry because they cannot produce children. Homosexuals are forbidden to marry because they cannot produce children." This defies the claim that the state law is animated by a general concern with channeling procreative sex for the sake of children. What makes it even worse, of course, is that many of those same-sex couples are actually raising children. So, constitutional values of equal liberty, it seems to me, argue strongly for marriage equality. The fact is that the state laws we're examining generally allowed same-sex couples to adopt children, and so many of those children many children were being raised in same-sex households. Now, the second question, and I'm going to be much more brief, is the inclusion of same-sex couples in the institution of marriage good for the institution and its public purposes? And my argument here is yes. Again, states opposed to same-sex marriage often claim to be concerned about children's well-being, but what about the 200,000 children being raised by same-sex couples nationally? As I said, Indiana and Wisconsin, like many other states, allowed same-sex couples to adopt but not to marry. Again, quoting Judge Posner, "Denying those children the emotional comfort and security of knowing their parents are married and exposing them to the taunts and ridicule that may well follow from other children's awareness of their family's second-class status in law." I mean, it's worth observing that the suicide rate among gay teens remains double that of others. But the question is, will same-sex marriage change marriage for all? And I think the answer is yes in some ways. If we ask the question, why is same-sex marriage even an issue now, as it was not 30, 40, 50 years ago, I think the reason is simple. Spousal equality. The women's movement and later formal gender equality in marriage is the major revolution in marriage of modern times, along with and supported by access to contraception and women in the workforce. And the fact is that if it weren't for the fact of spousal equality in marriage, which the women's movement achieved, same-sex couples would not be seeking marriage rights. Same-sex marriage reinforces spousal equality and gender equality in marriage because it doesn't replicate the differentiated roles of husband and wife, which has so often in the past been associated with patriarchy. Many conservatives want to preserve an understanding of marriage rooted in tradition that not only distinguishes husband and wife, but founds marriage on male headship. And I think that's one of the reasons why at least some conservatives oppose same-sex marriage. So if we look at same-sex marriage law as it's existed in the United States since the 1970s, 80s, especially the 90s, we can see that it performs three broad functions, and it does it just as well for same-sex couples as for heterosexual couples. It recognizes the couple's emotional closeness and supports that through various entitlements that married couples acquire, including immigration rights and hospital visitation rights and so on and so forth. It recognizes their economic interdependence. In fact, they tend to mingle their finances and so on, and they become economically dependent on one another. And again, that applies as strongly to same-sex as to opposite couples. And it facilitates the raising of children, and again, that's important for many heterosexual and homosexual couples. So it seems to me that if we focus on what marriage is in America, it requires very little shift in order to accommodate same-sex couples. And in fact, it just requires eliminating the prohibition. Now, as I mentioned, well, we could talk later on. I'm not going to say anything about the slippery slope towards polygamy. I'm virtually out of time. Let me mention one thing in closing, before I just say a brief word in closing about religious liberty. There is a big crisis in marriage, but it's not access of same-sex couples to marriage. It's the incredible class division that's arisen with respect to access to marriage. This has been talked about by Robert Putnam in his recent book, Our Kids. Others have talked about it as well in recent decades, including my colleague Sarah McClanahan and others. If you look at college, people marrying now under favorable circumstances when both spouses have a college degree, they're favorably situated to do well economically, to be secure. Those couples, the pattern is they're waiting to marry until they're in their late 20s. They're not waiting to have sex necessarily, but they're waiting to marry, and they're postponing having children until after they're married, overwhelmingly. And those marriages are very stable. They tend to be more equal than the marriages in the past, and they're as stable as marriages were back in the mid-1960s. On the other hand, if you look at people that have only some only some high school or a high school degree, the pattern is very different. They have more traditional attitudes towards marriage, thinking of the husband as a breadwinner, but the economic vulnerability of those people is such that they don't feel that they're ready because the husband can't be the breadwinner given our economic, the decline of manufacturing jobs and so on. So they're much more frequently having sex, but having children outside of wedlock, cohabiting and having children, with the expectation that the relationship will be stable, but overwhelmingly it's not. So you have many more single parent families coming out of that relationship. And unfortunately, those people would like to marry, but they feel they can't marry because of their economic insecurity. I think what we should be doing is to facilitate, it's going to be difficult, but to facilitate those people both planning their pregnancies more effectively, because many of those children being born are either unplanned or not fully planned, and that means providing more access to contraception, as well as other kinds of family planning, and also trying to do more to support those couples so that they can have a household and feel that they can get married. But it's the class crisis with respect to marriage that's the real big one in this country. And the reason being that those college-educated married couples that I mentioned, they're hyper-intense parents. We all know them. They spend a lot of time with their children. The husbands spend more time with their children than they used to. And those children are getting super preparations in life. Whereas, of course, on the other side, there's a huge deficit in the early education of children in the cohabiting families, and that's going to point to a widening class divide in the future, which is very dangerous. So I think that's the big crisis with respect to marriage, and I think personally that the debate over same-sex marriage has been a distraction from focusing on that. I'm supposed to say just a couple of words about religious liberty in closing, and I'm conscious of having gone over, so I'll be very brief. Obviously, there are new concerns that need to be negotiated in the wake of same-sex marriage. They require, I think, mutual understanding, reasonableness on both sides. These things are often in short supply in our politics, but I hope that we can achieve them. It seems to me that we should avoid overly sweeping pronouncements, such as is contained in some of the so-called Religious Freedom Protection Acts and policies that are being called for. And there's no doubt that governments pursuing legitimate and important public aims may impose burdens on religious believers and organizations, even as an incidental side effect. And I agree that reasonable accommodations often need to be worked out. And sometimes that's what people seem to be calling for under the rubric of these religious freedom restoration acts that are now being enacted at the state level in many places. This is what Douglas Laycock has said, that what's important is that we have a discussion, have a conversation, just so people can talk to each other in good faith on both sides of these disagreements. And I agree with that. The problem is that the RFRAs often go too far in establishing a strong presumption in favor of religious dissents from generally applicable laws. And that includes the act in Indiana and elsewhere. And the fact is that because it's important as a general matter that in the civil rights laws and acts in the 1960s and subsequently, that the state took a stand, and I think we all embrace this as a country, that in the public realm, in the marketplace, restaurants, accommodations, and in employment, there's a danger of people being discriminated against on arbitrary grounds. And sometimes religion might be used as a rationale for that kind of arbitrary discrimination, denying people access to employment, to housing, to restaurants, to hotels, to places of public accommodation broadly. It was essential to making good on the claims to equality of African Americans that they'd be free of discrimination in the affairs of ordinary life. And those sorts of issues apply equally to gay and lesbian Americans. If you open a restaurant, you must serve the public, not just Republicans or white people or Christians or those without disabilities, and so on. And I think we generally accept that. Preventing private discrimination in these general affairs of life avoids the creation of a balkanized caste society and seems to me to be a compelling state interest. And there's often no less restrictive means than generally preventing acts of exclusion on grounds of race, sex, ethnicity, religion, and sexual orientation. Now, obviously, there's going to be a ministerial exemption for those employees who have a direct role with respect to the religious mission of a church or a faith-based institution. And I don't have any broad, principles or rules here to sort out the difficult issues that will remain. I haven't studied these as closely as I would like to. But I think most people will agree that sometimes claims for religious liberty go too far. I mean, the Kim Davis case, the Kentucky county clerk who refused to not only issue marriage licenses herself, but refused to allow others in her office to issue the marriage license to which people were entitled, went too far. That was her job, and there would have been ways of having these marriage licenses issued by her office, even if she did not want to be involved with them herself. Sometimes the burdens that are complained of are not very substantial. The Little Sisters of the Poor at 4 Christian colleges in Oklahoma sued over the federal health care law. I mean, they were already exempt from covering contraceptives because of an exemption built into the law, but they claimed that filing the piece of paperwork necessary to get the exemption made them feel complicit in providing the contraceptives and was a religious burden. That seems to me to be going a bit too far. The Hobby Lobby case I have very big doubts about. We're talking about a corporation with 18,000 employees. The corporate form is a public privilege. The corporation is a fictive person distinct from the persons of the stockholders. That's the whole point. It seems to me somewhat anomalous to allow the owners of a publicly chartered for-profit corporation to assert their religious liberty interests as the interests of the corporation. That seems to be the whole point of the corporation, is to distinguish the fictional person of it from the individuals that own it. Elaine photography, the wedding cake makers, and so on are harder cases. There's no doubt. And when it comes to those kinds of cases, it does seem to me there's a case for carving out, with respect to wedding services, an exemption, so that it's available to everybody. To a Jewish Orthodox baker, say, who doesn't want to cater or photograph an interfaith marriage, and so on. So I think there are definitely places where accommodation should be carved out. I don't have a formula for that. I don't have a prescription for that. But I think we should avoid sweeping too broadly because there is a real worry of providing a blanket license for discrimination. So anyway, I apologize for going on longer than I should have, and I will cease at this point.
First, thank you guys for being here tonight, and thanks for inviting me to speak. And thank you to Professor Macdeo. As he mentioned, this is the first time he and I have discussed these issues publicly. I've read many of his academic articles, and I just finished his new book here. I take off the dust jacket when I read it because I don't want to suggest necessarily that I agree with what I'm reading. Really, it's just more cumbersome. So I can't put it up as a free advertisement for him, but just in case you were wondering what the purple book is, it's underneath the dust jacket. Let me say a couple of things. I don't want to respond to what Professor Macdeo just said. I just want to kind of give what I was intending to say, and then I think we're going to get into the back and forth afterwards and during the Q&A. But I'll try to signal with what I had prepared where I think he and I agree and disagree. Let me just say one thing up front is that we agree that marriage matters, that marriage is important, that a marriage is important to a free and virtuous society, that it's important for the common good. That's why we've both written books about this issue. And we agree that the arguments on both sides are good arguments that are worth engaging, and that they're worth engaging in a civil and a respectful way. So I think one thing that you'll notice about tonight's presentation is that this won't become CNN or Fox News or MSNBC. No one's going to cut my microphone. We're not going to be shouting at each other. And I think that's important because too often this issue in particular devolves into name-calling and shouting And I think Professor Macedo's done a wonderful job kind of setting things up tonight as to what the expectation is. Let me start by turning back the clock the way any conservative should, to 50 years ago. 50 years ago, Senator Daniel Patrick Moynihan, while he was Secretary Health and Human Services, writes his famous Moynihan report on the state of the black family in the United States at the time. And what he points out is that while births to single mothers in the general population were in the single digits, births to single mothers within the black family were approaching 25%. He was criticized for being a racist for writing this report. I mean, here you have a liberal senator from the state of New York, a liberal sociology professor from Harvard University. He wrote the report precisely because he wasn't a racist. He said, something's going on, that we're seeing a divide between black and white when it comes to family structure, when it comes to childbearing. Fast forward 50 years to today, and we see that the divide really wasn't between black and white. It still exists, but we're actually seeing the class divide that Professor Macedo discussed. And you see this in Professor Putnam's book, you see this in Charles Murray's book, Coming Apart. Today, 40% of all American children are born to single mothers. It's 50% of Hispanic kids, and it's 70% of African American children. These children have done nothing wrong. Frequently, these mothers have done nothing wrong. But something has gone wrong within those family structures and those relationships that we have 40% of all Americans today being born to single moms, whereas 50 years ago it was 5%. Gays and lesbians aren't to blame for this. The problem of non-marital childbearing is not to blame with gays and lesbians. They're not the ones creating fatherless homes and fragmented families. Liberal ideology, I think, is partly to blame for this. So I did think it was interesting that Professor Macedo points out that lower class families are where it's coming apart, and it's because of conservative ideas of patriarchy. I'm not so convinced that that's the case. I think what's happened in the past 50 years as a result of the sexual revolution is that we got a culture change in which the overriding cultural value is that consenting adults should do whatever consenting adults want to do. So it's coming out of the 1960s, coming out of the sexual revolution, that you get the rise of the hookup culture. It's where you get the rise of the acceptance and normalization of premarital sex. It's when you get the increase in the rates of non-marital childbearing. It's where you get the increase in cohabitation, the increase in the rates of divorce, and then the introduction of no-fault divorce laws. Now, no one denies that some of the changes that have taken place in the past 50 years were necessary and good. Women's equality was necessary and good. Some of the divorce reform that we got was bad, but was necessary. Some of the old divorce laws were overly restrictive, but what we got instead was overly permissive. Unilateral no-fault divorce is now one of the weakest types of contract in American law. You have more legal obligation to your roofer or your plumber than you do to your spouse. And so it's not surprising that after this cultural redefinition of marriage, and this is where we got slogans like, marriage should last as long as the love lasts, love makes a family. Gays and lesbians didn't create those slogans. Those slogans were simply extended to the equal sign of love equals love. The cultural redefinition of marriage that took place where heterosexuals bought into a liberal ideology about sex and the family preceded and set the table for the legal redefinition of marriage, which took place in courtrooms over the past decade. Anthony Kennedy and the 4 liberal Supreme Court justices could only redefine marriage in our law and say the Constitution requires it after we had a generation or two of straight people failing to live out the truth about marriage. It's only when you have 40% of all of your children being born to single moms, it's only when you have 40 to 50% of all of your marriages ending in divorce. So when you're not taking the sexual exclusivity or the monogamy or the permanence aspect of marriage seriously, that you can then take the sexual complementarity and say it doesn't matter either. Now here's the question. There's a logical connection here. Is it a good or a bad logical train? So if you think the hookup culture, the rise of non-marital childbearing, the increase in the rates of divorce, the increase in cohabitation have been good things for children, for women, and for the American community as a whole, then by all means cheer the principles of liberty and justice that you might think were enshrined in the Obergefell decision and cheer its conclusion. If you think they've been problematic, that this is actually a bad train of logic, you might want to be more cautious before you enshrine this train of logic into the US Constitution and say the 14th Amendment guarantees this train of logic. We might actually want to take a step back and reconsider these things. What was at stake in the Supreme Court case? What my co-authors and I argued in the book that Professor Macdeo mentioned was that there are two different visions of marriage on offer. One vision we had called a revisionist vision. It was one that had changed and had revised what had been the historic understanding of marriage. Professor Macdeo quotes Alec Baldwin on this. I think it's a very good representative of it. So I was able to pull up the page in his book where he quotes Baldwin, so I can read it back. This is what he had just mentioned. They seek only companionship and all the entitlements that come with marriage: sex, joy, partnership, caring. So that's one vision of marriage. Marriage is about companionship. It's about sex, joy, partnership, and caring. On that understanding of what marriage is, the sexual complementarity of spouses doesn't matter. It can be two men, it can be two women, it can be a man and a woman. I'm going to suggest in a minute that whether it's permanent or exclusive or monogamous also doesn't matter for that vision of what marriage is. So it's not just sexual complementarity that's at stake with that understanding of marriage, but it's all of the historic marital norms. Because I'm going to argue that sexual complementarity is the foundation upon which the justifying principle of monogamy, exclusivity, and permanency are built. But for now, to say, look, that's a vision of marriage, and on that understanding, sexual complementarity doesn't matter. There was a different vision of marriage on offer. This is what my co-authors and I had called the conjugal or the comprehensive understanding of marriage. This is an understanding of marriage where spouses unite at all levels of their humanity. Therefore, it's a union of hearts, minds, and bodies. That there's a particular marital act that will unite spouses as one flesh, that when the Hebrew Bible uses the phrase of the two becoming one flesh, it's not speaking poetically or metaphorically, that they're so much in love, it's as if they become one flesh. No, the Hebrew scriptures are revealing something that's true about human nature at both the physical and the metaphysical level, that when a man and a woman unite in the marital act, they become husband and wife because they become one flesh. That this union that they form is then ordered towards the creation of new life. So there's a comprehensive act that then is ordered towards a comprehensive good, the creating and then the raising of new life. And that this therefore explains the comprehensive commitments that spouses make to each other. A comprehensive commitment throughout time, the permanent commitment, the comprehensive commitment at every moment in time, the exclusive commitment. Our Constitution is silent on which of these two substantive visions of marriage is true. Which of these two substantive visions of marriage is the best for our society, the best for men, women, and children, the best for our public policy. And where the Constitution is silent, one of the norms of democratic reciprocity and legitimacy is that we, the people, make these decisions, not 5 unelected judges. And so we're now in a situation in which 5 unelected judges on the Supreme Court have settled the issue of marriage, at least temporarily, saying that this vision of marriage is the true vision and that this vision of marriage is the false vision, when there's nothing in the Constitution that would give them any sort of way of adjudicating that question. They simply replaced their philosophy of marriage for the people's philosophy of marriage. So I don't think the outcome of the Supreme Court ruling is a good ruling for equality or for justice or for democratic Republican self-government, particularly constitutional self-government. I think this is an example of judges ignoring the actual text, logic, history, and structure of the Constitution and simply inserting their own policy preferences. I had said before the ruling that everyone I know is in favor of marriage equality. I imagine everyone in the library tonight is in favor of marriage equality. We want all marriages treated equally. What we disagree about is what type of a consenting adult relationship is a marriage. And even if you're in favor of treating a same-sex relationship as a marriage, you're probably going to draw other lines. So one of the things that Professor Macdeo does in his new book is explain why he wants to extend marriage equality to same-sex couples, but not to same-sex thruples or opposite-sex quartets. Professor Macdeo thinks marriage should be a monogamous relationship, and he makes public arguments for why marriage should be the union of 2 and only 2 people. I think those arguments ultimately fail once you get rid of male-female sexual complementarity. If you say that the male-female, the husband-wife, the mother-father part of marriage no longer matters, that it's unconstitutional, that it's irrational, that it's bigoted, that it's arbitrary, it strikes me that you're on much weaker grounds for explaining why marriage is and ought to be a union of 2 and only 2 consenting adults. Take the Alec Baldwin understanding of marriage. Why can't three men who live with each other and love each other, who want to cook meals for each other, who want to sleep with each other, who want to have a joint checking account, who want to file a joint tax return, why can't they have marriage equality? The term that I mentioned, throuple, is not the creation of me or Sharif or Professor George. It's not the creation of some right-wing think tank. It's a term that gay activists and other liberal activists have used to describe their own relationships. We came across it in New York Magazine. They were profiling three men in Brooklyn who lived with each other and loved each other and cooked meals for each other and slept with each other. And the question that we raise, and the question that we have now seen raised by several of the US Supreme Court justices, is that if marriage equality requires treating the same-sex couple as a marriage, why not the same-sex throuple or the opposite-sex quartet? Justice Alito, during oral arguments, asked the Solicitor General, let's take 2 men and 2 women. Let's assume all 4 of them are lawyers, so we don't have to worry about problems of consent. They all know their rights. They can all consent. So you have this foursome. They're all lawyers. They consent to live with each other and love each other. Professor Macedo mentioned 3 things: emotional closeness, economic interdependence, and the raising of children. So they're emotionally close, the 4 of them. They want to be economically interdependent, and perhaps they want to raise children. And these kids are going to be even better than the ones that have 2, one mom and one dad. They're going to have 2 moms and 2 dads. Talk about economies of scale. What would be the limiting principle? So, but it's not just the throuple, which is one of the terms. Another term that we came across was the term monogamish. This is a word that Dan Savage created. Dan Savage is the founder of the It Gets Better campaign, which is an important program. Professor Macedo is right when he says that suicide amongst gay teens is much higher than other populations, and it's a problem. And so, to his credit, Dan Savage has done something constructive to stop that. But he's also done some things that I think are somewhat misguided. And so this was an article, a profile of him in the New York Times, the Sunday magazine. It was titled, Married, with Infidelities. And the reporter asked him, well, what will straight couples learn from gay couples once we have marriage equality? He said they'll learn the virtue of the open relationship, the monogamish relationship. So it's a union of 2 people, but it's not so uptight about infidelity. Remember the title, Married with Infidelities. And his argument was that straight people have this outdated holdover from Christianity or Judaism in which one person can fulfill all of your sexual desires for the rest of your life. His argument was that gay relationships tend to be more sexually open, more honest, and that provided there was no coercion and no deceit, so you weren't forcing your partner into this, you weren't lying about it, provided you were open and honest about it, there's no reason in principle to think that marriage should be a sexually exclusive relationship. Marriage could be a sexually open relationship, and that would actually improve marriage in America. So when Professor Macedo said that changing marriage to include same-sex couples will change the institution, I don't think he's cheering on this change, and I think he probably doubts that this change will take place. But there are other voices, the people that he's engaging in his book to criticize, who are actually saying, yes, this is a change that will take place, it should take place, and it will be a good thing. Because there's no reason why consenting adults can only consent to an exclusive relationship. They could have an open relationship. The last term, this came out the month after the Defense of Marriage Act was decided by the Supreme Court. So it's a little over 2 years old now. It was in the Washington Post, and it was the term wed lease. Wed lease is a play on the word wedlock. Wedlock denotes something strong, sturdy, permanent. Wed lease was meant to denote the opposite. This was a temporary marriage license. And the idea here is that just like you can lease a car or you can lease a house, why not be able to lease your spouse? And that the problem with marriage is that we think it needs to be a permanent relationship. But if marriage is just about consenting adult romance and caregiving, emotional union, the pooling of assets, what in principle requires it to be a permanent commitment? We weakened it with no-fault divorce. We now see half of marriages are ending in divorce, but it still is an expectation of being permanent, and then you have to file for divorce. Why not just have a 5-year marriage contract, a wed lease? If it's going well, you can renew it. If it's not going well, it would automatically dissolve. The same way that if you guys have a lease on your dorms, your apartments, your cars, you're not locked in for life. Nothing in life should be permanent. And how can you expect to live and love one person till death do you part? That's outdated. Let's update wedlock with wed lease. Now, I'm not talking about morality or theology tonight. I'm just thinking about the public policy and the common good implications for these changes. So I'll leave it to you and to your theology professors to evaluate the wed lease, the throuple, the monogamous relationship in terms of morality and theology. Think about the public policy outcomes. I've argued with my co-authors that the reason the government is in the marriage business is not because it's a sucker for romance. The state's not in your bedroom because it cares about the butterflies that you get in your stomach when you fall in love. If that was all marriage was about, consenting adult romance, we wouldn't have government in the marriage business. I've argued that the reason the state's in the marriage business is to get one man and one woman to commit to each other permanently and exclusively so that any children that are created will have both a mother and a father, committed to each other and committed to the child. But if you get rid of the male-female part of marriage, if you get rid of the procreative aspect part of marriage, if you get rid of the mothering and fathering part of marriage, what is your principal basis for saying marriage should be a union of two and only two, should be a permanent relationship, and should be a sexually exclusive relationship? The throuple, the wed lease, the monogamous relationship, as a logical matter, not as a slippery slope matter, as a principled logical matter, follow, just like night follows on day, once you get rid of sexual complementarity. Once you say male-female sexual complementarity is no longer part of our marriage culture or our marriage law, it strikes me as very hard to explain these other marital norms. So what I'm suggesting here is that we weakened these marital norms in the first place through the sexual revolution. So we had a cultural redefinition of marriage. That then has led to a legal redefinition of marriage to eliminate male-female sexual complementarity. And that now poises us to be on the verge of another legal redefinition to eliminate expectations of monogamy, exclusivity, and permanency. And if marriage is simply about your adult love lives, your consenting adult romantic relationships, why should the government privilege this one sort of consenting adult relationship over other forms of consenting adult relationships? Why should it pick winners and losers in the consenting adult romance business? What business of the state is it? How many sexual partners you have, how long they last, and whether they're open or exclusive? Strikes me as much harder to explain why government would be regulating your sex lives once you get rid of the male-female part. What will the likely consequences of this be? I think one of the first things, and the reason that I mentioned this in the context of the Moynihan report, is that the teaching function, the pedagogical function of marriage law, will now be teaching that marriage is primarily about the desires of the adults involved, rather than the needs or the rights of any children involved. So it'll be teaching that men and women are fundamentally interchangeable, and therefore mothers and fathers are replaceable. Rather than saying that this is about gender equality, I think it's ultimately going to be a form of saying that the genders are interchangeable. Whereas before we wanted to say children deserve both a mother and a father because men and women are equal in dignity and equally important in their lives of their children. Now we'll be saying two moms or two dads is the functionally same thing as both a mom and a dad. And so today, as Professor Macdeo mentioned, the pressing social issue in our time is the fact that 40% of all kids, 50% of Hispanic kids, and 70% of African American kids are being born to single moms. How do we insist that those fathers are essential when the Supreme Court has redefined marriage to make fathers optional? What will you learn? What will your children learn? What will your grandchildren learn about marriage and parenting and family structure in a culture, in a legal culture in which marriage has been redefined to eliminate complementarity? Let me close, because we want to get to your questions. Let me just close on the religious liberty bit. So I'll close where Professor Macdeo closed. What we have seen in the past decade in jurisdictions where marriage has been redefined and where the phrase sexual orientation and gender identity has been added to existing anti-discrimination statutes that were passed to combat racism and sexism have now been updated to include sexual orientation and gender identity. That's what Houston is voting on today. We'll see what happens when we're done this lecture. Maybe someone has already figured out on Twitter on your iPhone. But what's at stake here, where these laws have been passed, where marriage has been redefined, is Christian-run adoption agencies have been shut down. Catholic Charities of Boston was the first one to be shut down back in 2005, 2006. Then Christian Evangelical Adoption Agency in Illinois, San Francisco, and where I live and work in Washington, D.C. These were agencies that simply said, we want to be free to find children homes with moms and dads. We have orphans that people have entrusted to our care. We want the freedom to find them homes with a married mom and dad. They were then told by the government that's illegal discrimination. Unless you treat married same-sex couples exactly the same as you treat married moms and dads, you're denying marriage equality, and we won't allow you to do that. This does nothing to help kids. Catholic Charities in Boston was probably the most successful adoption provider. They were able, whether it's Christian charity or Catholic guilt, they were able to get more people to be willing to adopt hard-to-place kids in particular. They had a capacity to get families to be generous, to open up their homes to children who were in need of homes. Gay and lesbian married couples were free to adopt from the state-run agency. They were free to adopt from the secular agencies. Why did the government need to coerce and then ultimately shut down Catholic Charities? What we saw during oral arguments, I was in the courtroom during arguments, and this was actually a chilling moment during oral arguments. Samuel Alito, Justice Alito, asked the Solicitor General of the United States, what's going to happen to Christian institutions, Orthodox Jewish institutions, Latter-day Saint institutions of higher education and of primary education, so think about grade schools, if they continue to teach that marriage is the union of a man and a woman? And he cited the Bob Jones University precedent. Here you had a private four-year religious college that didn't allow interracial dating on campus. The IRS stripped them of their nonprofit tax status. He said to the Solicitor General, is that going to happen to Orthodox Jews, Roman Catholics, evangelical Christians, Latter-day Saints, any institution that continues to teach that marriage is the union of a man and a woman, a husband and a wife? The Solicitor General's response was, I don't deny it, Justice Alito, that's going to be an issue. I don't deny it, it's going to be an issue. He said it twice. 2 days after the Supreme Court ruled in the marriage case, the religion columnist for the New York Times wrote an op-ed in Time magazine titled, Now's the Time to Revoke Nonprofit Tax Status to Christian Institutions. So this is what you're seeing at stake here, is whether or not the full and equal status of social conservatives, of socially conservative religious traditions, of social conservative natural law thinkers, will they be respected in law and in culture? Will they be free to live out their understanding of what marriage is? Lastly, I'll mention the wedding professionals. The examples that we've seen involving bakers and florists and photographers have not been people who say, I refuse to serve you if you're gay or lesbian. That's not what has taken place. What's taken place has been people who say, I have no problem baking you a happy birthday cake. I have no problem doing get well soon flowers for you. I sell get well soon flowers to gays, lesbians, straights. I don't ask them about that. Happy birthday cakes regardless. My only objection is to doing a same-sex wedding cake, to doing the wedding arrangements for a same-sex wedding, to being the photographer who captures the first kiss at the same-sex wedding. They've argued that they are conservative Christians of various denominations, that they view these artistic gifts and talents as gifts from God, and that they think it would be violating their conscience to help tell the story or to help celebrate a same-sex wedding that goes against their understanding of what God intends for marriage. It strikes me that in a free and tolerant society, we would say if you're in favor of gay marriage, bake a gay wedding cake. If you're not in favor of gay marriage, don't bake a gay wedding cake. And instead, the bakers in Oregon were fined $135,000 for not baking the same-sex wedding cake. There's a 71-year-old grandmother who is still in court being sued by the state of Washington because even though she's had gay employees, she's employed gay people at her florist shop, she was selling flowers to this particular gay couple for a decade. When the gay couple asked for her to do the wedding flowers, she sat down with one of them, his name's Roger, explained to Roger why he couldn't do the wedding flowers, and then the attorney general for the state sued her. And sued her in both her professional and her personal capacity, going after both her business and her home. Again, in a free, tolerant, diverse, liberal society, we don't force the grandmother to violate her beliefs. It's not as if in the state of Washington and the state of Oregon, evangelical Christians have a monopoly on cake baking and floral arranging. There are plenty of businesses that support gay marriage and are interested in making money. And a much more American solution would be let the market sort these things out. We don't need government picking sides one way or the other. So it strikes me in terms of the future that what we need to do is we have to be able to say we agree to disagree about marriage. I'm going to continue making arguments for why I think marriage is the union of a man and a woman in a permanent and exclusive relationship. Professor Macdeo is going to be making arguments for why he thinks it's two people in a permanent and exclusive relationship. So we both have critics on our left. I think we should be able to make those arguments without having the government penalize either of us. So none of our universities should be losing their nonprofit tax status. I think Eastern should have the freedom to be authentically Christian. I think BYU should have the freedom to be authentically Mormon. Notre Dame, authentically Catholic. Princeton to be authentically Ivy League-ish. I don't know what Princeton's, it was once Presbyterian. I don't know how they define themselves today. That's part of pluralism. It's not that everyone becomes the same. It's that we allow everyone to operate according to their deepest convictions. In the same way, I think, with the adoption agencies, have the secular humanist adoption agency, have the Episcopalian adoption agency, have the government-run adoption agency, also have Catholic charity adoption agencies. None of us are better off by shutting them down. And have a variety of bakers, florists, and photographers. We don't need the government settling this one way or the other. Thank you.
I was wondering if you could comment on the category of civil unions, and if you think that that would be helpful for either of your stances, because they may provide some of the rights, but still recognize a differentiation between the types of relationships.
Should we say a word about it? I'm not opposed to civil unions, but marriage has a distinctive meaning in our society, and that's what same-sex couples want access to, because marriage signals lifelong commitment. The marriage vows are the same; they haven't changed. They simply not husband and wife, but partner and partner in marriage, and that's what same-sex couples. It seems to me that meaning, the social norms that are attached to that, are important. They're important to same-sex couples. And so that seems to me quite important. I do want to just take this to, if I can, insert one little thing in. So I just want to say one thing, which is I think the core of Ryan's argument is that sexual complementarity of heterosexual couples is necessary to supporting. It's the logical underpinning of the norms of marriage, two-ness, or monogamy, permanence, and exclusivity. And I just think that's clearly false. 85% of societies in human history have had normative polygamy, a husband with multiple wives. Those marriage institutions were all founded on sexual complementarity. They would have thought it was ludicrous to have any other arrangement than a husband married to all of those wives. So it was founded as much on sexual exclusivity as the model that Ryan has in mind. And sexual exclusivity itself, sexual complementarity itself, does not lead logically to any of those other norms. If monogamy makes sense, it's because human beings are constituted such, and I think Ryan and I agree with this on different grounds, such that human jealousy being the kind of factor that it is, that sharing a life in common with another person is difficult enough. Bringing in a third person would make it impossible. It's especially egalitarian marriage, where the spouses are equal. I mean, if you've got one leading partner and the others are all subordinate, well, then you can make multiple people work because there's one person in charge. But with a reciprocal relationship of sharing your life in common on an equal and reciprocal basis, two makes a lot of sense. And I'm just going to say this, Ryan has cherry-picked a lot of quotations out of New York Magazine and other. It's a big world out there. There's a lot of craziness going on. You can go to the Jerry Springer show and other places where, people appear in all kinds of weird relationships. Well, but this is not a harbinger of the future. There's no society in the world in which women are equal. There's any movement back in the direction of plural marriage. Everywhere that women are becoming equal, monogamy rules. And all of the evidence suggests that monogamy is consistent with human equality, the fair sharing of the opportunity for the great good of family life, and the goods that we associate with marriage under liberal democratic conditions. So it seems to me that monogamy makes sense on its own bottom, not because of anything that has to do with sexual complementarity. As I say, sexual complementarity was there in those 85% of human societies that had normative polygamy.
Sure, let me just say a couple words about that. I think it would be very odd if someone was to argue against gay marriage by saying weird people exist, and there's, let's say it's 40 years ago. Weird people exist, and there are these gay people, and then you can find them in the internet, and they're in magazines, and they want to get married, but they're weird and they're fringe, and so we don't have to take them seriously. There's no mass movement arguing for it. Now, you could have argued that way 40 years ago about the gay marriage issue, but I think that wouldn't have been the best way to approach it. I mean, the best way to approach this is to think, what is the principle that singles out this sort of consenting adult relationship for particular normative importance within our public policy and excludes all other consenting adult relationships? And it doesn't matter statistically how many of them exist, or whether we think they're weird or not, or whether they're, prominently displayed in liberal publications. It's not cherry picking. I mean, in the past 2 years, it seems like every week there's another left-leaning magazine that profiles a throuple or a wed lease or monogamy. We could fill books just by taking the headlines from various, and these aren't conservative publications, these are liberals. People have responded to Professor Macedo's arguments, disagreeing with him from the left, both academics and popular writers, looking at places like Salon and Slate, the New York Magazine. So I don't think that's how we should be approaching this. I mean, what we're looking for is, what is the normative principle that says, just because Steve thinks a two-person union has less jealousy or is more stable, why won't the government recognize my three-person union if me and my two partners think that's the relationship that matters most to us? That it's the union that has the most emotional importance, that has the most commingling of assets. It's the union that's going to allow us to raise our children most effectively. What's the justification for Steve saying, Professor Macedo saying, you have to be in a monogamous relationship if you want the government's recognition and the institution of marriage, that monogamy is the line that can't be crossed? And it strikes me that historically it has been sexual complementarity, because even in the 85% of societies that Professor Macedo mentions, it's not as if 85% of the actual humans were engaged in polygamous relationships. Even where polygamy was tolerated and accepted at the top of society, the norm in those very societies was monogamy for the vast majority of the inhabitants. Just do the math. You can't have the majority of your people doing polygamous relationships. It's not going to work. So what happened was high-status men, several of them, not the vast majority, but a vast minority of them, would be in these polygamous groupings. But the majority of the citizens, the majority of the people in these communities were engaged in monogamous relationships, precisely because it's a man and a woman who can unite as one flesh, create new life, and then detach new life with a mother and a father. That's what's been normative, even in societies that did have polygamy at the top.
Bill? Can we get the answer to the question about civil unions?
Oh, sorry. I can't remember if it's in the What is Marriage book or in an earlier, I think it's an earlier essay that Sharif Gerges and I wrote. We said that, look, there could be a compromise in which you said, let's have civil unions for a variety of consenting adult relationships. Let's not make it marriage light, because I think Professor Macedo is correct that neither of us want to see a kind of separate but equal category. So we had said that this wouldn't be limited to sexual relationships. So one of the reasons in the book where we mentioned the three monks, we said, look, there are lots of non-marital relationships where a civil union could benefit people. And then we arguing in that specific thought experiment was that it's not just the presence of children that makes something a marriage. You have to explain what the connection between the adult relationship and the children is. And our account of marriage can explain how the lovemaking act is also the life-giving act. The act that unites a man and a woman as husband and wife also makes them mother and father. And so that can explain the intrinsic connection between the spousal relationship and the children. And we said there isn't any intrinsic connection, for example, with the three monks. It was it wasn't to somehow denigrate gay relationships, to say that on this particular point, there's not that intrinsic connection any more than there would be with the three monks. So if you were to have civil unions, we would say you have to open them up to lots of different types of consenting adult relationships, not just to same-sex couples.
Phil. So, shouldn't the conjugal view of marriage accept polygamy as a possible form of conjugal marriage for the following reason? Jacob marries Rachel. Jacob marries Leah. Those are two marriages, both conjugal. They're not a throuple. Jacob doesn't go to bed with Rachel and Leah together. So shouldn't polygamy, for instance, in the Old Testament, count as a version of conjugal marriage?
So polygamy has a much greater claim to marriage, on our understanding of what marriage is, than same-sex relationships do. We think of this with an Aristotelian analysis of focal cases versus peripheral cases. We think the focal case is going to be, even in polygamy, they're all conjugal relationships. So, Jacob and Sarah, Jacob with Rachel, conjugal relationship, another conjugal relationship. I think the problem here is that what they fail to understand is that the type of commitment that conjugal comprehensive act and union requires is a comprehensive commitment. Comprehensive both throughout time, that's the permanent commitment that we make to our spouses, but then also comprehensive in being an exclusive commitment. We only unite in this way with our spouse. So the reason why marriage doesn't call for intellectual exclusivity, none of you are cheating on your spouses by being at this lecture, is that it's not an intellectual act that unites spouses as spouses. It's a sexual act that unites spouses as spouses. And so the type of exclusivity that marriage calls for is sexual exclusivity, because it's a sexual act that makes them one. The mono part of monogamy, it's that conjugal act that makes them one flesh.
It's interesting the fact that you mentioned that the problem with that kids are being born that are being raised to single mothers and in the minority communities. I would like to ask, how does that problem relate to the problem with gay marriage? If this is a problem for society, in your view, do you have a solution?
Yeah, great question. So what I was trying to say, and by opening by saying that gays and lesbians aren't to blame for this, was to say that my main concern with the marriage is what can we do to strengthen marriage? You know, it's not what can we do to prevent same-sex marriage. The focus should be on the marriage part, not the same-sex part. That it's a worldview, a philosophical foundation that is shared by both the non-marital childbearing and the hookup culture and no-fault divorce and cohabitation, with the extension and the redefinition of marriage to same-sex couples. That they're all along a logical train, and that once you understand marriage as primarily about consenting adult romance and caregiving, there's a certain logic that works its way out with the rise of the hookup culture. If consenting adults want to do it, if consenting teenagers want to do it, who's to say otherwise, with cohabitation, with non-marital childbearing, and then eventually you get to where we are with the Obergefell decision. I also had then mentioned that it's very hard to say in culture that fathers are essential when the Supreme Court has now said that fathers are optional. And it'll be very hard to communicate this, particularly in the public school system and in other institutions where government will now be teaching something about marriage. What can be done? I think that ultimately what needs to be done is a recovery of a sound understanding of marriage and the virtue of chastity. And I think both of those things will be harder to do in a legal culture where marriage has been redefined.
It seems to be we can teach responsible sexuality and responsible fatherhood very directly. I don't think that everything is logically connected the way that Ryan seems to think. It doesn't all follow from one principle. And it's not the case that every person that's committed to equal liberty is committed to the hookup culture and all of the other things that you mentioned. Those are all quite separate. And I think it suits his argument to lump all this stuff together. But it needn't go together. There is a question about what the role of the government is in, for example, criminalizing the use of contraceptives. We're long past that. It was decriminalized for heterosexual couples. I don't think that using the criminal law to police people's sexual lives is appropriate. But there are other ways in which we can encourage responsibility than rolling back the clock to a time in which the criminal law was a central instrument for this. And in any case, I just don't think that all of these things necessarily go together. Nor do I think the package that Ryan is talking about goes together. Let's remember, Ronald Reagan was divorced. Newt Gingrich proposed an open marriage to his second wife before he divorced her. There are problems embedded in our marital culture, and they have nothing to do with homosexuality. I guess Ryan has conceded that. But I think the question of the virtues of chastity and so on, this becomes a very difficult conversation about sexual ethics. And I doubt that we're going to come to one view on this as a society. And I think the law has to be respectful of the variety of reasonable views that are out there with respect to some of these matters.
Peter?
It seems to me that we've, in some ways, confused the idea of progress and change in public policy, largely, I mean, in this case, marriage, but in many different areas of our lives that have been a certain way for a very long time. And we've confused the act of changing them with progressing and moving into the future and becoming better human beings. I'm wondering how this, this kind of redefinition of marriage, or a reevaluation in a way, might benefit us, but also might hurt us in a way that we treat ourselves differently than people have in the past. We think we're different persons than people have in the past.
Is that for you? Or?
I think it's for either or both of us. Do you want to go first, or should I?
I have nothing right now. Let me think. You go.
It kind of reminds me of the debate between Lord Devlin and H.L.A. Hart. I think it's a good point. The fact that social norms change tell us nothing about whether they're improvements or degradations. So I think with all of these things we need to think about, if we think that equal rights or basic forms of equal respect for gay and lesbian people is a requirement of fundamental liberty, because what's the alternative? Driving people back into the closet and so on, and requiring or encouraging people to engage in heterosexual marriages that are unhappy for them, that's the solution. On the other hand, we can accept basic equality and think about how to temper other aspects of this sexual culture that I agree with Ryan can be problematic, both for individuals and for society as a whole. But I think we just need to sort these things through. There's nothing about equal rights for gays and lesbians that in any way requires moving towards moving away from the norm of monogamy. As I say, that I think that this is there's nothing about that argument that goes together particularly. So I think we can sort these things out. We needn't accept the idea, which I just think is false, that there are two packages of values out there, and it's either A or B. It's either a kind of intolerant moralistic traditionalism, or kind of anything goes liberalism. And this is caricature. And unfortunately, it's the kind of caricature that drives the polarization of American politics. There's a sensible middle. The vast majority of Americans are coming to accept equal rights for same-sex couples. They're not sexual anarchists.
So, I mean, the way I heard the question was, what will be the good, but will there also be some bad? That there will be some positive aspects of the change, but will there also be some negatives in how it changes us? I'm not interested. I joked at the beginning because conservatives are frequently caricatured as wanting to turn back the clock, right? So I'm not interested in putting anyone in a closet. I'm not interested in having the government criminalize gay relationships. What I'm concerned about is that I don't think it's simply scaremongering to say that certain ideas hang together, that there are conceptual connections between various worldviews, and that the certain logic within those conceptual worldviews played themselves out over time. And so what I have seen for the past 50 years is an introduction of an understanding of human sexuality that says consent is the only value that really matters. And you probably see this, I don't know what actually Eastern is like, but certainly when I was an undergraduate at Princeton, the only thing that was taught about sexuality during our Sex on a Saturday Night freshman orientation program was it better damn sight be consensual. Because if it's not consensual, you're going to be expelled, it's going to be date rape, it's going to be bad. Now we see all the statistics across campuses of the problem with non-consensual sex on campuses. I don't think that that's unconnected from a general idea that says sex in general is a recreational activity that once you reach an age of maturity, healthy adults should be engaged in. And we keep moving back the post of what counts as healthy adults, right? So now, if you watch most TV shows, it seems like if you're in high school, consenting high school students should do whatever they want to do sexually, provided it's consensual. One way of illustrating this is that I've done a lot of reading, listening to various speakers and their lectures on YouTube, and researching this question. I've never heard someone publicly advocate for same-sex marriage and publicly advocate for chastity. And again, Steve is right. There's no logical reason why it's impossible to do both of those things. But as a lived reality, and I've read lots and lots of books and articles and watched lots of talks and interviews, I've never seen someone do it. And even today, when Professor Macdeo was given the opportunity to do it, he talked about responsible parenting. Right? And so it's a question of what is responsible parenting? Does it mean marital parenting? We had a campaign to prevent teen pregnancy, and what it did was it just pushed it back into early 20 pregnancy. It didn't actually result in more marital pregnancy. It just was delayed non-marital pregnancy. And one of the reasons why was that they were willing to say teenagers, you shouldn't be having kids. There wasn't a cultural consensus on you should be married before you have kids. And there's still a cultural divide on that issue. And so I do think how we understand the nature of the human person and our embodiment as male and female, how we understand the marital relationship as an embodied union or as primarily an emotional union, who sets the terms of the marital relationship? Is it kind of built into the nature of marriage, or is it the consenting adults who get to consent to the terms of marriage. All of those things are conceptually connected. This is where I think we disagree, and that's why I think we are seeing them play themselves out in different ways.
Well, I just want to say for the record that neither Alec Baldwin nor Newt Gingrich set such a high standard for marriage in our country. I don't think Kim Basinger would think so, at least. Ryan, you said at the end of your talk that what we have to do is focus on the public policy issues and find a way to agree to disagree. But I wonder if you really mean that. Because Professor Macdeo then also talked about finding a middle ground, and let's not push this argument beyond where ordinary Americans find it comfortable right now to deal with it. So my question is, particularly to Professor Macdeo, but also to Ryan, is the right of same-sex individuals to marry just a matter of legal right, or is it also a matter of moral right? And if it's a matter of moral right, what is the foundation of this moral right that you'd be willing to apply in general? Would that be the idea that human beings are equal in some sense? If so, are they equal in nature? Are they equal in the right to pursue personal desires? Or in what respect is it the moral right of same-sex individuals to marry?
Right. We're equal in having certain basic interests, all normal human beings, normal adults who have achieved maturity, in equal liberty and having the freedom to pursue a conception of the good life within responsible bounds and limited by the equal rights of others, and in having a capacity to understand our moral requirements vis-a-vis others and to pursue them. Now, so obviously there's a basic moral equality that all people share. I mean, nature is a problematic basis because we're going to disagree probably about human nature in certain fundamental ways if we try to base it in that. But obviously I think that human beings have an equal. And then I think when it comes to marriage, we think about what kinds of social institution. I think marriage is a social institution. Can we secure for all the equal opportunity to pursue the great good of marriage? And what I see when I look at polygamy as a social form, rather than as it's featured by a particular couple in New York Magazine or the Washington Post or the liberal magazines that Ryan looks at, not the liberal ones that I look at, because I haven't seen much on polygamy. And these are blogs, of course. He's talking about the Slate blogs or the Economist blogs. I mean, there's a lot of blogs out there associated with these publications. But there is no society in human history that has ever institutionalized equal plural marriage. Never, ever, anywhere. There's not a single study of it, because all we have is anecdotes and so on. And it's conceivable that 50 years from now we're going to look back and say, oh, it was just about to emerge this stable, egalitarian form of plural marriage that's consistent with gender equality and so on. It's possible, but frankly, it seems to me that if this was a form of human, I mean, I could be wrong, if this was a form of human flourishing that was consistent with basic equalities, that we'd see it in Amsterdam and San Francisco and Greenwich Village. I mean, I don't know what would be stopping people. I just don't see it. And what we do see is, anyway, everywhere in the world that plural marriage exists, it tends to take the form that we've seen, and it's not consistent with human flourishing, human health, or good health outcomes for children as well as women within those relationships. So, in fact, all the advantages that same-sex couples claim for marriage are not there with plural marriage as a social form. It's not consistent with human happiness, except for the happiness of rich men. It's inconsistent with the happiness of lower status males who find much harder to get a spouse, and women and children. So in fact, I think that if we're thinking about the public policy angle, which is what I would do, as many liberals have argued, including Rawls and Dworkin, monogamy is part of the basic structure of a liberal democratic society. That's my argument. It has quasi-constitutional status, given what we know now, as part of the basic structure of a liberal democratic society. I was going to just mention one other point about Ryan's position, where he wants to see these two packages of logic unfolding, either his logic or my logic. My logic leading towards sexual anarchy, his logic being the only one that's consistent with norms of sexual self-restraint, fidelity, and so on and so forth. Well, I don't know what Ryan's views are on these matters, but I've looked at the new natural law views that provide a coherent underpinning for the particular views that Ryan has. And on that view, all sex that's not uncontracepted sex in marriage is morally equivalent. And it's all morally wrong. Now, I don't know how many Americans accept that view, but it's darn few. Germaine Grisey and others who defend the view that the natural law view that underlies the views of, I think, 2 of the 3 authors of that book, takes the view that for a married couple to use contraceptives is morally equivalent to gay sodomy, because it cuts off that sexual act from the good of new life. Now, look, if that's that may be that anything other than that view, that picture, leads towards sexual anarchy, well, I'm just afraid we have to try to deal with that, because I don't think hardly anybody accepts this view. I mean, what percentage of sex acts of heterosexual couples in the United States fit the model? Of this, it's a very small percentage. Look, it's not inconceivable but I just don't think this is very, very far from being a plausible view of a coherent picture of American public policy. So I think we need to deal with the sexual revolution just as we need to deal with gender equality, which and other matters, and there are things we can do. And if sensible people got together and stopped talking about packages of logic that will inevitably unfold in kind of a Hegelian manner, which I don't believe in, then I think we could get somewhere at the practical level concerning public policy, because I suspect there is a fair amount of agreement. We're both in favor of carving out some exceptions for the cake makers and so on, the people that attend wedding ceremonies and so on. Yes, I think that's a very reasonable thing to do for people who have conscientious objections to the particular nature of the wedding ceremony. With respect to other publicly funded. What's that?
What's the moral principle that
See,
ought to
there's a
inform
fundamental
the law?
mistake here that runs through the book, which is to say, all of our rights are founded on principled arguments because they're consistent with all sound principles, and they represent packages of interests that make sense. There's no fundamental principle that defines the First Amendment, right to freedom of speech. It's a complicated thing. There are a whole bunch of interests that come to bear on shaping the First Amendment right to freedom of speech. It's not one principle. There's no principle of human rationality from which you can deduce the shape of the First Amendment. That's a mistake that's been abandoned by political theorists decades ago. So in fact, I think Ryan and his co-authors are always looking for the wrong kind of argument. There has to be an in-principle argument that explains why and it's always a fake principle. It's some principle that is asserted to contain all of the conclusions, in fact, that they want to follow from it. But those implications are simply being stipulated. They're not there. So what we look for is an argument that's consistent with all sound moral principles, including basic human equality and freedom, but that represents a combination of interests, basic interests of human beings, and that takes all those relevant interests into account. And when it comes to marriage, and I think what it counts is the fundamental interest that everyone has in settling down with another person, the clear deliverance of human history, that monogamy does that in a way that's consistent with equal liberty of all. And the case against polygamy rests on the history of polygamy and what it amounts to as a social form, not a bogus principle of sexual complementarity, which is perfectly consistent with polygamy.
Okay, so a lot there to respond to. One is to suggest that Professor Macdeo needs to do more reading. This isn't just fringe blogs. These are most of the mainstream magazines that kind of set the tone for American public life. So I just did a quick Google search for the word marriage, equality, and polyamory. Because it's also interesting that Professor Macdeo has written an entire book about polygamy when none of us are talking about polygamy. We're talking about polyamory. When I mention a throuple, that's not a polygamous relationship, that's a polyamorous relationship. It's 3 people all married to each other. So all the responses he's given is saying, well, historically, patriarchal societies practice polygamy. Historically, fundamentalist Mormons is what he talks about ad nauseum in the book. About all these, that's not
actual people.
Well, but that's not the proposal on the table, right? The philosophical question here is what sort of a consenting adult relationship is a marriage? And you can't answer that question by talking historically of how marriage has been practiced in patriarchal ways in various traditional societies. So here's one, June 29th, 2015. So this is just a few days after the Supreme Court's rules on same-sex marriage. Says, title, the headline for U.S. News and World Reports, that fringe blog. Polyamorous rights advocates see marriage equality coming. Then you can go to Politico magazine. Politico, another very fringe website. No one in D.C. reads it. Title, it's time to legalize polygamy. Then you can go to Slate magazine. That one was on June 26th here. June 13th, polyamory should be legal. It's consensual and fine for children. Huffington Post headline, why are gay marriage advocates not defending polyamory? So again, whether you think these are good or bad arguments, I don't think you can just dismiss them as saying they're fringe arguments and they're bloggers somewhere in their pajamas in the basement of their mother's house talking about it. I think we actually need to understand, why are you saying that the free and equal liberty of gay couples should be instantiated in law with gay marriage, but not the free and equal liberty of people who are interested in thruples or wed leases or monogamous relationships? What is the justifying purpose for these norms? Professor Sheehan, the answer to your question was, yeah, I was being serious. I said that I'm going to continue advocating for why I think marriage is a union, a permanent and exclusive union of a man and a woman. Professor Macedo is going to continue advocating why he thinks it's a permanent and exclusive union of any two people. And that in terms of the religious liberty aspect, in terms of which schools should be losing their nonprofit tax status, which bakeries should be penalized by the government, we just have to agree to disagree and let those institutions operate according to their beliefs. But underlying that was, I'm going to continue to be making the public argument, because I think here's how we can respect the full and equal dignity and liberty of our neighbors who we disagree with. We define marriage accurately. So justice and equality requires the government to treat all marital relationships in the same way. So to know what justice and equality require is to know what the nature of marriage is. So we have to have a discussion about marriage, understand what marriage is, and then you can have marriage equality, you can have justice respected. Then I say non-marital relationships, let consenting adults be free to live and to love how they want to, but the government doesn't have to treat every consenting adult relationship as a marriage. Professor Macedo and I are going to draw different lines as to what is a marriage. I think I can have a better explanation of why it's not extending to thruples, monogamish, and wed leases. He thinks he has a better explanation of why it's not being extended there. But I think that's going to be the nature of the disagreement. It's the title question of my previous book, what is marriage?
Time for maybe one or two more. Yeah, in the back there.
So I guess my question is, I think it's one thing to look at it in an academic setting and say, can we make a rational, reasoned argument for why polygamy would be bad for democracy? But when I look at the culture at large, it's not how it appears that they make the decision. It appears that it's a changing of the imagination of what I want to picture something to be, and I see that it's framed in terms of individual rights too. This is something that I desire, I should have the right to pursue it. So I guess my question is, if you don't have a moral principle that you're using to determine the context and boundaries of what is considered marriage, can you expect that our civic society is strong enough that we can look to something that's pointing to the good rather than just saying, here's what I want? Because I don't see that without a moral principle that you can make a case against polygamy that's going to trickle down all the way through to the popular imagination.
Yeah, there isn't a real moral principle on the other side either, it seems to me, because I don't accept Ryan's claim as being resting on a principle. It seems to me it rests on a whole bunch of different reasons. And if we think about why two-ness makes sense, I think we're going to have to say more than talk about the sexual act for reasons that were offered from the back, among others. So what we have to do, what we do in a liberal democratic constitutional discourse is to try to think about what institutionalized forms are consistent with equal liberty for all adults. And as I tried to explain, it's often the case, look, the shape of First Amendment law is not defined by any principle of human rationality or any moral principle at all. Its shape is defined by a whole set of concerns, especially since what kinds of things can we trust the government to do when it comes to regulating freedom of speech? Time, place, and manner restrictions and so on have to do with the requirements of social order. We define our fundamental rights as a political community based on a whole bunch of human interests and human considerations that are principled at the end of the day if they're consistent with real human principles, but they don't emanate from a single principle or some which is simply a bald abstraction. So in fact, I'm proceeding in a way that's very consistent with the history of American constitutional law, going back to the founding. I think that there's a kind of romance of abstraction on the other side, which is kind of has a false attractiveness to it to the extent that you find it attractive. But like I said, I just don't think that there are any implications that follow from these kinds of bald abstractions. Now, again, there are all these people out there. There's no question that the popular media finds polyamory fascinating. As I said, not a single systematic study of it. On the other hand, there's a federal court case in Utah involving actual polygamists. There are 60 to 100,000 people living in polygamous relationships in the United States. I dare say that that's far more living in polyamorous relationships. But people find it titillating. People find the idea of open marriages titillating. Those go back hundreds of years, thousands of years. There were utopian experiments and so on that have failed. Open marriages, heterosexual open marriages have been talked about since the 60s and 70s. They haven't taken off. So look, all of these things need to be dealt with at retail. They can't really be dealt with adequately, it seems to me, from the point of view of very broad abstractions. We need to think about what kinds of social arrangements are consistent with human flourishing as free and equal people. And as I say, everything we know about polygamy as a social practice suggests that it's not. They want to rely on speculation in U.S. News and World Report and these other places, which is frankly speculative, which people, it sells copy, there's no question. But there's nothing there but speculation, anecdote, and free love fantasy. That's all there is to it at the moment. There might be something more, but that's all there is now. I mean, it does sell copy. People, people love to think about this stuff on People magazine and so on. But there's nothing there in terms of scientific study or sound understanding.
So a couple months ago, Cambridge University Press published a book arguing that there's a better constitutional argument for marriage equality for polygamous and polyamorous relationships than there is for same-sex relationships. Cambridge University Press is a fringe publication. It's added to my list of straw man arguments.
Ronald Den Otter.
All right, so I mean,